Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. And this edition we look at what happens when someone dies without a will and how to become the administrator of an estate. When the person dies without a will, that's called intestate. The administration must be open in the county where the person resided at their death. Now, the person who's seeking to become in charge is called the administrator. If there's a will, that's called the executor. And the person who wants to become the administrator, the first right is spouse, second children, third parents. So who has the right to become the executor? Well, if all the children agree, one person can, but the other children have to sign what's called a renunciation. So the attorney prepares these renunciations for the other children to sign. However, if any of the children won't sign the renunciation, then the surrogate can't act, and you need to have your attorney file a complaint in order to show cause to have you appointed as the administrator of the estate. So one of the reasons for having wills is to avoid this hassle of having to go through this administration. What you need to bring if you're applying for the administration, well, all those signed renunciations, let's see, certified death certificate, a list of all the assets and the approximate value, bank account information, and bring a check for the filing fees. Thereafter, you have to go out and get what's called the surety bond. The surety bond is the purpose under the statutes to protect the heirs and creditors so that you're not stealing. The surrogate sets the bond amount, then you have to go and hire a bonding company. So again, one of the reasons for having wills is to avoid this thing called the surety bond. And you have to pay fees every year on the bond until the estate is wrapped up, and there's a release and a refunding bond filed by everyone, or there's an order by the court finishing this up. So you always want to try to avoid trying to go through the administration and having the valid will. So if someone can't find, if you think you have a will, you can't find it, get a new one. The surety bond, in essence, is purchased from an insurance company. If there's there's a will, most good attorneys put a clause in saying a surety bond is not required. And how is this bond released? Well, you have to either get approval by the court or all the beneficiaries sign a release and refunding bond. Now, there's other information. Now, the rest of the duties of the administrator are same as the executor. Make sure that all the taxes and bills are paid, file the tax returns, and you usually get an attorney to assist you with that. For other information, contact the law office of Kenneth Vercammen, 732-572-0500 in Edison. And we also have other information on our website, njlaws.com, and our other websites. So if you want to become the administrator, call us and we'll try to help you out. Thank you.